Good afternoon, everybody. Thank you to Thomson Reuters. Thank you to Westlaw. Thank you to Celeste. We're getting underway here. To give you a short introduction and background of myself. My name is Massimo D'Angelo. I am a real estate attorney here in Manhattan. I handle anything having to do with real property law, including, but not limited to condo co-op, construction defect cases, complex lease issues between landlords and tenants, adverse possession cases, Yellowstone injunctions, which we'll be taking a look at a little bit later during the lecture. I also engage in transactional work, drafting of leases, other contractual transactions dealing with real property here in the city. I also act as general counsel to many cooperatives and condominiums throughout the city, as well as to property owners and developers. And it runs the gamut. Anything having to do with real estate, I handle. You can contact me on LinkedIn. I generally post on LinkedIn all of my press releases, my recently published articles. I publish a lot on all sorts of topics dealing with real property and real estate law, as well as my court victories are on LinkedIn. So please do feel free to connect with me on LinkedIn. Also, if you want to take down my personal email for faster response, it is, if you're ready, Massimo, which is my first name, M as in Mary, A as in Andrew, S as in Sam, S as in Sam again, I, M as in Mary, O, period, F as in Frank, period, D'Angelo, my last name, D as in David, A as in Andrew, N as in Nancy, G, E as in Edward, L, O, at gmail.com. So again, that's Massimo, period, F, period, D'Angelo at gmail.com. So please do feel free to send me an email if you have any additional questions after the lecture, during the lecture. If you require further details, case citations, whatever it is, please do feel free to email me. I've also listed my cell phone number on the lecture materials. It's 732-232-1617. Again, do not hesitate to reach out with any questions. So the timing for this lecture is really perfect as we're in the eye of the storm, so to speak, still with COVID-19. I am in New York City, which has been denoted the epicenter of the COVID-19 pandemic, and it really has struck home. The last day that I was out was before the shelter in place was put into effect March 20th. On March 11th, 2020, I realized personally the gravity of the pandemic. Okay, it was right around the time that Tom Hanks had tested positive, and the NBA, along with the other sports leagues, had just shut down. And I really had a realization. I came to the realization as to how potent and pernicious the virus was. You know, I had seen the reports from Italy, people piling up and dying in the weeks before that, but you know, I didn't realize the veracity of this extremely virulent contagion until that time. So the last day that I was out was March 12th, 2020, and you know, having come to that realization the day before, I was getting on the subway. I knew I was going to be with a lot of people on the subway. You're packed like a sardine. I had a court appearance in the morning, so I bought an N95 mask, which apparently is the only real mask that protects against the spread of the virus from the microbes. From what I understand, it's constantly changing every day, but you can get infected by this virus through the coughing, sneezing of another person who's infected, which then gets into your eyes or your mouth or your nose. And apparently it also spreads through the touching of high-touch surfaces like handrails on the stairs, doorknobs within your buildings. And then you touch your mouth, and that's how you infect yourself. And we've already seen a sea change in how life is conducted as a result of this virus, and we're going to continue seeing that. I think there's going to be an exploitation of these antiviral paints. They're going to be painted on all high-touch surfaces in buildings. I mean, that's probably a completely different topic for CLE, but the changes that are going to come about because of this virus are so many. So I went to court, as I was saying, on March 12th with this mask on. I rode the subway with the mask. It was the last day I was out in public socially, and I argued a case in court with my mask on. And the judge didn't ask me to remove it. It was a very surreal experience, hopefully one that I'll never have to live through again, but only time will tell. So I live here on the Upper East Side of Manhattan. I've been running 3 miles a day since March 12th, 2020. I usually leave my house between 9 p.m. to 10 p.m. in order to ensure that I can properly socially distance myself from people while I'm jogging. And as of this morning, today's Thursday, May 14th, 2020, I just pulled up the most recent figures on the infection rate and the death rate, mortality rate of COVID-19. We have, in New York State alone, 338,000 confirmed COVID-19 cases, and we have, as of today, 21,845 deaths. In the U.S., we have a total deaths of 84,763. So you can see the level of cases in New York is quite substantial when compared to other parts of the country. So we're really, really here at the epicenter. We now have nearly 300,000 people that have died around the globe because of COVID-19, which is a dramatic increase. I prepared these materials 2 weeks ago. On May 1st, I completed these materials and submitted them. At that time, we had about 200,000 deaths. So within a 2-week period, there's another 100,000 deaths worldwide, which gives you some sort of, the parameters of how pernicious this disease is. I also represent a number of multinational companies that are headquartered abroad. I also represent domestic companies, and a large part of my current legal work within the last few weeks since the shelter-in-place order started in mid-March here in New York, I have been negotiating force majeure cases on behalf of those clients all across the country. California, Texas, Florida, New Jersey. I'm also, I have one in Nevada against one of the famous hotels on the Strip. Never thought I'd be writing a demand letter to a Las Vegas hotel. But that's what I'm doing, a lot of it, and that's what we're going to be touching on during today's lecture. We're going to be going through not only the history of force majeure, the case law, prevailing authority, how it came about and developed throughout the years, but also we're going to be looking at the current state of affairs and the application of force majeure in the context of contractual relations between parties, and when you can use force majeure, impossibility, impracticability, frustration of purpose, as the case may be, to substantiate non-performance under a contract. We're also going to be taking a look at business interruption, business coverage, and applicable coverage issues resulting from COVID-19. So in mid-March, shortly after Governor Cuomo's shelter-in-place orders were issued, and states across the country issued very similar orders, I had a client, one of my clients passed away. I was actually in the process of negotiating rental relief on his behalf under force majeure with the landlord. He was a famous restaurateur in Soho. His passing was well publicized in the press. It was in the Post. Some local politicians even posted their condolences for my client on social media. And my client's son is now actually running a citywide fundraising campaign for personal protection equipment, also known as PPE, for the city's residents and medical professionals. The disease really has hit home, especially here in New York City. For those of you who are listening in New York City, you're living it, you're well aware of it. There have been 14 New York judges that have now tested positive for COVID-19. 3 judges died. Justice Stephen Milgram, 66, up in Orange County. We've had 2 judges from Brooklyn die, Judge Johnny Lee Baines and Noach Deer. Our director, national director of the National Institute of Allergy and Infectious Diseases since 1984, the eponymous Dr. Anthony Fauci has indicated that between 200 to 240,000 Americans are going to die due to complications with COVID-19. So judges, as well as, a large part of our society, are scared, and for very good reason. We have also, we have this medical and scientific data regarding the virus, which seems to be changing on an almost daily basis. For example, the first reports we had were that you were supposed to socially distance for 3 feet. Now people are saying it's at least 6 to 10 feet. I've also heard some reports saying that the virus or the viral matter upon somebody sneezing or coughing can spread up to 27 feet. There was a video that was studied and released coming out of Wuhan, China, where the disease apparently came from. There are also conflicting reports about that. Some people say it came from a seafood and poultry market. There are other suggestions saying that it was created in a lab. But this particular video was of a man on a bus who apparently had the virus. He was infected. He was coughing and sneezing, and he ended up infecting others on that bus who were sitting, up to 30 feet away from him. So it's extremely scary, the level of infection and the extreme virulence of the disease. There's also a substantial debate on, I think it's more so now, but whether you can get the virus twice, or if you are rendered immune after you have overcome the initial symptoms. So, the fact is that we still don't know very much about this virus, and what we do know is that we need to continue to exert a tremendous amount of caution. So without further ado, let's jump into the lecture on the, force majeure case law. There's going to be significant developments in the law, as you will see here as we, chart our course going forward. So taking a look at the history of force majeure, now we're on page 1 of the outline starting here. Force majeure, or vis major, which is in Latin, it's generally defined as a superior force, right? Something beyond normal control. Here is I think a pretty good definition from Pollock on contracts. It is defined as an event which is between the parties and for the purposes of the matter in hand cannot be definitely foreseen or controlled. Okay, so the typical force majeure provision you find in many contracts excuses the parties from liability or some contractual obligation upon the occurrence of an extraordinary event or a circumstance beyond the control of the parties. And take a look. The first order of business is always taking a look at the actual contract. What does the contract between the parties say? And there may be various clauses within the contract. For example, if you have a commercial lease between a landlord and a tenant for retail space, there may be provisions in that contract which specifically abate the rent in the event of a damage or other casualty or fire. But then you might have later on in that lease a force majeure provision saying that in the event of a force majeure, the rent does not abate. So then you have a conflict between the two paragraphs. So you have to dig a little further and then look at the case law for each of you, whatever particular jurisdiction you're in. So there are non-exhaustive examples of force majeure. You have the typical war, strike, riot, epidemic, criminal conduct, act of God, which we'll be taking a look at further below, and some of the case law on. Acts of God are specifically defined under the case law and are not necessarily synonymous with force majeure unless they're defined as such. So what we do know is that an act of God typically is a force of nature, like an earthquake, a flood, a volcanic eruption, a hurricane. And then we have, I put in here a practice tip. So again, the first order of business is to analyze the language that's employed by the contractual provision to determine whether you have force majeure or an act of God event, which triggers the clause. If you have that, the next step then is to determine whether it's limited in duration, as some clauses do not excuse non-performance indefinitely, but they rather suspend performance during the specified force majeure event. So, and that comes really into play with the current COVID-19 situation and is unraveling daily here and in different states is staggering at different times. For example, in Texas, they've already, and it's been a few weeks since they have started to do these staggering openings. So if you're doing a negotiation on a contract in Texas under force majeure, that time, so long or insofar as the space is now back open and any government orders have been lifted, that force majeure time period may be over or coming to an end very quickly. So you have to, in conjunction with the contractual document, look at what's going on around you in terms of governmental orders or decrees allowing business or operation to open up as usual. So let's get into some of the history and the most important cases that fundamentally establish force majeure. So force majeure, we know, can be traced back to the English common law. Here it's the pertinent case is Taylor v. Caldwell. It's an 1863 case from England. Very cool venue in South London in 1861. There's an event organizer contracts with a venue owner to rent out its facilities, and it consists of the world-renowned Surrey Music Hall and the adjoining Royal Surrey Gardens. I'm a big history buff, so I like to pull up and especially being a real estate attorney, when you're dealing with these cases, whether you're litigating, you're doing a transaction, you're dealing with actual physical building with history to it. So I like to look at the buildings or the structures that pertain to the particular case. So this is the Surrey Music Hall. It's the Surrey, Royal Surrey Gardens. Very, very beautiful. It's no longer there, unfortunately. It's now been turned into housing complexes since the 1970s. That was done, but it was a stunning, majestical place. So they were going to host this 4-day concert series here. There was a separate music hall, adjoining gardens across the street. You can walk in and, you know, have a good time. There were promotions for this concert. It was going to be a very big event. And according to the contract's payment terms, the event organizer agreed to pay the venue operator an installment sum after each day of the concert. However, of course, as we know in the law, everything doesn't always go as planned. So prior to the first concert, there was a fire. It was deemed to be an accident, and it completely destroyed the music hall. And the contract did not have a force majeure clause. It's a very, very pertinent issue. And the critical issue in the case was whether the event organizer's losses were recoverable. The court held, the esteemed Justice Blackburn, that the principle seems us to be that in contracts in which the performance depends on the continued existence of a given person or thing, a condition is implied that the impossibility of performance arising from the perishing of the person or thing shall excuse the performance. So this was the first actual case that carves out force majeure. And the reasoning is that because from the nature, the very essence of the contract, it is apparent that the parties contracted on the basis of the continued existence of the particular person or thing, right? Here, the rest or the subject matter, the real property where the concert was to be held was destroyed. So it makes performance impossible. Prior to Taylor, the doctrine of impossibility did not apply to executory contracts. What's an executory contract? It's a contract that has not yet been fully performed or fully executed. The parties still have important obligations extant under the contract. So some examples, if you may remember from law school, executory contracts, you have real property leases, right? Both commercial and residential. You have to give me a roof over my head going forward under the lease in order to for me to pay you so that it's tenable. Construction contracts are usually done in installments, same concept, leases for equipment or other personal property, and licenses, intellectual property, sporting events, and this list is non-exhaustive, just by way of example. So as we talked about, following Taylor, the English courts, as well as the American courts, began creating additional exceptions to excuse performance under the principles of force majeure. So now we have it coming over from England, across the pond. We fast forward 8 years. In 1871, the New York Court of Appeals specifically extended Taylor to cover non-performance under force majeure under New York law. And we have the famous case of Dexter versus Norton in 1871. Okay, Dexter is the first reported force majeure application of Taylor in New York. Some of the facts, you can take a look at the case. I've included them in the materials as Exhibit 1. But the defendants on October 5th, 1865 in New York City, they agreed to sell and deliver to plaintiff 607 bales of cotton bearing certain marks and numbers specified in the contract at the price of 49 cents per pound, and 14 bales bearing marks and numbers specified in the written contract at the price of 43 cents per pound, the cotton to be paid for on delivery. However, what happened in Taylor, there was a fire. Here, same thing. Defendants delivered to the plaintiff only 460 bales of the cotton because 161 of them were accidentally destroyed by fire and without the fault or the negligence of the defendant vendors. And, naturally cotton rose in value after the sale, so the plaintiff commenced a suit. to recover on the lost bales and to cover his lost profits. If you look at actually many of these first tranche of force majeure cases, particularly in New York, you'll see they dealt with the commodity of cotton, which was, as we know, a very big commodity then. Dexter was in action. It was brought, as I said, by the purchaser against the vendor to recover these damages under the contract and under the circumstances where the property or the subject matter is destroyed by accidental fire before delivery without fault of the seller, there's no liability. So the court applies Taylor. You'll see there's a specific reference to Taylor in that case. It extends it. And the court held that delivery was rendered impossible. The vendor can't perform, force majeure. This is the first real case in New York with Taylor cited. So I've also included in these materials here New York's original Constitution. It was signed in 1777 in the city of Kingston, which I don't know if many of you know, but Kingston was New York's first designated capital because it was deemed safer than New York and Albany, which were occupied heavily by the Redcoats at that time. New York Constitution extended the common law rule before Taylor that inability to execute under an absolute executory contract due to a subsequent unforeseen accident or misfortune without the fault of either party did not excuse performance. So I have here the specific citation to the Constitution of 1777, Article 35. I've also included a link to it in the footnotes if you want to take a look directly. Here's the language. It's italicized here on the point that we just discussed. And I really love the language here from the old Constitution. And it says specifically, and of the Convention of the State of New York now in force and not repugnant to the government established by this Constitution shall be considered as making part of the laws of this state. So you see that there. Dexter v. Norton, we just went over the facts and the holding on that. That was the first application of Taylor. Then we get further into the expansion of the impossibility and impracticability doctrine. In re Tornado, an 1883 United States Supreme Court case and aptly named. Here are the facts. On February 24, 1878, a ship appropriately called the Tornado, while it was moored at the wharf in New Orleans and it was bound on a voyage to Liverpool, England, caught fire in her hold for departing. The ship was supposed to deliver, again, cotton, our favorite commodity, most of which was destroyed as a result of the fire and water damage. The contract, again, did not include a specific force majeure provision. So the holding in the Tornado case was that the impossibility doctrine enunciated in the Taylor ruling would be extended because the ship was destroyed and could not deliver the cotton. So the parties were excused from performance. It's no fault of either party for the fire. Again, it was deemed as accidental. Here, there are also some court-created exceptions where the legal impossibility arises from the change in the law. Here we have the impossibility of performance arose from an order of the Board of Health of the City of New York prohibiting the landing of a cargo of coffee. That's Jones v. Judd. Also, where the specific thing which is essential to the performance of the contract is destroyed. Again, that's what we looked at in Dexter versus Norton. There are a plethora of other cases along that line of rationale, some of which are cited here, where by sickness or death, personal services become impossible. And I've included here another case on Spalding v. Rosa, which is Exhibit 2 in the materials. That's an 1877 case. And you see here some of these cases in this line where there is a personal services that are being conducted. In Rosa, the defendants contracted with the plaintiffs, who were the proprietors of a theater, to furnish the Wachtell Opera Troupe to give a certain number of performances. And the parties were going to divide the receipts in certain specified portions. And the company was so styled by the well-known name of its leader, Wachtell, from whom the troupe took its name. He was the leader and the chief attraction. Everybody was going to see Wachtell. And, you know, his connection with the company was why the plaintiffs entered into the contract in the first instance. However, Wachtell, because he got ill, was unable to sing. And the consequence of that was that he did not perform. So, of course, plaintiff sues in an action to recover the damages for the breach of the contract. And the court again cites to Taylor and held that the presence of Wachtell, which was the principal thing contracted for, although the thing here is a person instead of a bale of cotton, was the essence of the contract. That the plaintiff would not have been bound to accept the services of the troupe without him, and that the sickness and disability of Wachtell, having occurred without his fault, constituted a valid excuse upon which non-performance could be based and was a good defense to the action. So there we have it with the personal services. All right, but I'd like to look at the comparison case. Conversely, the court in a much more recent case refused to extend that similar doctrine of impossibility where a boxer's bout was called off after the boxer tested positive in a drug test. So this is probably one of the cooler cases that we're going to look at. It's Exhibit 3 in your materials. It's World of Boxing, LLC versus King. Everybody knows Don King, right? Mike Tyson's unscrupulous boxing promoter with that iconic long hair standing straight up. This is a 2014 case. And here are the facts. The May 17, 2013, Jones and Lebedev, two professional boxers, had an original fight, their cruiserweight title fight. It was in Moscow, commissioned by the World Boxing Association. Jones won the fight by knockout in the 11th round. It was a great fight. Both of the boxers, were going at it. It was a heavily contested fight. After the bout, however, Jones's urine tested positive for furosemide, prompting an investigation by the WBA, which is the World Boxing Association. On October 17, 2013, the WBA found Jones guilty of using a banned substance, stripped him of the cruiserweight title, suspended him, and sanctioned him. He said he couldn't fight for 6 months. So January 28, 2014, King and the WOB, they finalized terms for a second administration, a follow-up fight between, following up on the storied first fight between Lebedev and Jones. Interestingly, in the agreement, King represented that he held the exclusive promotional rights for Jones, and he promised to cause Jones to participate in the rematch. There were several restrictions that were also imposed by Jones in that contract. He had to arrive in Moscow a certain minimum of days before the second fight. And, finally the rematch was finalized for April 25th, 2014. However, on April 23rd, 2 days before the fight, the urine samples were collected from both boxers. They were submitted for testing. And on the day before the fight was supposed to happen, there was a report that came out that found that Lebedev's sample was clean, but the Jones, his test came back positive again for furosemide, which is a banned substance. So they learned the news. It became a big deal. The fight got called off. And here, the court refused to extend the doctrine of impossibility. Why? Because the boxer's actions were fully within his control, right? He could have not taken the banned substance. The fight would have proceeded unimpeded, but it was his decision. It's not like Wachtel, who got sick before he had to sing. Here, the boxer took a drug he knew was banned or should have known was banned, was fully within his control, and impossibility, therefore, was not extended. So, rational decision here, and here you see the interplay of how fault comes into play when evaluating the doctrine of impossibility or force majeure. You also have some cases where the conditions are essential to performance do not exist. The impossibility, for instance, in Whipple v. Lyons Beach Sugar Refining Company, where there was a drought and other climatic conditions prevented the defendant from carrying out a contract to grow a certain number of acres of beets for a sugar company. You have impossibility. Also, a very, very good case is Kinzer Construction versus State of New York. That's Exhibit 4 in the materials. And it has a good recitation, I believe. It also cites Taylor, but it's got a great recitation of the history of force majeure and its application. So I would really push you to read it fully if you have the time to do so. In that case, the contractor was excavating for one of the locks for a canal. An extensive cave-in occurred, which revealed that the earth was of a quote-unquote slippery, greasy clay, insufficient to allow for the construction according to the contract, plans, and specifications. So accordingly, the Kinzer court ruled that although the contract did not expressly cover this contingency, it rendered the performance of the contract impossible, as the law will read into the contract an implied condition when it was made that such a contingency will terminate the entire contract. So here's a practice tip. Although the contract is terminated upon a finding of impossibility or impracticability, the contractor is still legally permitted to recover quantum meruit. You remember that legal principle from law school? Quantum meruit damages, to get back the reasonable amount of services that are rendered by one party under a contract. So even when impossibility comes into play, it is critical that one party is compensated for the work that they do under that particular contract, even if it is later found that an event of impossibility or impracticability occurs at a certain point, right? That party still has to be compensated for the just work that they did up until that event is triggered. So this brings us into the COVID-19 pandemic. The destruction in the wake of COVID-19 has been on a scale really never seen before, right? It's the first time in U.S. history that every single state in our union has declared a state of emergency. On the scale of pandemics, it is ravaging the globe. Probably one of the worst in human history, at least on an economic level. But not only in terms of its virulence, the destruction that it is causing to our economy is beyond words. So I touched on this a little bit before. There is some discrepancy as where the virus originally emerged from, whether it was really from a poultry market. Some people say it came from a bat or an animal. Some people say it was genetically manufactured in a lab. The answer is we don't know. We simply don't know yet. But what we do know is that since we've learned about it, it's quickly spread throughout the world. If you look here in the notes, again, this figure is outdated. It says 200,000 people have died. That was true as of April 24, 2020. That number is now increased dramatically in the last 2 weeks. We're now at 300,000 people. So it's increasing prospectively around the world on a daily basis. And according to reports from Dr. Fauci, as I said before, we could have up to at least 240,000 Americans die as a result of this disasterly disease. So we know scientists are working towards a drug, antiviral drugs, a vaccine. We don't know when that's going to occur, but as a consequence of that, we have these strict governmental lockdowns that have been imposed, okay? And we have, a lot of similarities between COVID and the Spanish flu of 1918. It's actually incorrectly called the Spanish flu of 1918. And we'll get to that a little later on in the lecture. But as I said, the economic disaster has been tremendous in the state of New York here. We have Governor Andrew Cuomo. He has issued a string of executive orders. The same has been done in every other state. And if you are negotiating these force majeure issues in other states, take a look at the executive orders because they're going to come into play in the context of your negotiations. Essential businesses here in New York and across the country have been shut down. So most businesses are shut down, and the restaurants have been impacted probably the most greatly out of any other business. The food, hospitality industries, the hotels. Really, it's transcended every sector, but many people think that the restaurants, especially the mom and pop restaurants here in the city, will never open again, will never be the same. So I've also included here as a sample the executive order that was issued in the state of New York, 202.10. And if you look at the last paragraph, that's Exhibit 5 in the materials. Take a look at that last paragraph. It reads in pertinent part, non-essential gatherings of individuals of any size for any reason, parties, celebrations, social events, are canceled or postponed at this time. Okay, so I recently made international headlines. I was on CBS News. I obtained the first emergency temporary restraining order here in New York City against the renegade shareholder who was violating his building's COVID-19 protocols and this particular executive order. The shareholder was circumventing security at the front desk. He was sneaking in guests through the garage and then bringing them up to his apartment through the elevator to throw parties. And I obtained successfully the first injunction issued in the state of New York on an emergency basis to enjoin this shareholder from violating these rules. So the most important part, as I mentioned earlier, in these evaluations is to first look at the contract. Before we get there, though, as we see here in the footnotes, on March 12, 2020, the Supreme Court of the United States announced its indefinite closure. It was the first disease-related closure since the 1918 H1N1. And there are a lot of similarities between the 1918 flu and COVID-19. Also here we went through, everybody knows about the CARES Act. That's probably a separate topic for an entire CLE section in and of itself. The last time our planet witnessed a contagion of this magnitude, nearly a century, almost precisely a century ago, scarily. It was mischaracterized as the Spanish flu. If you take a look here at footnote 9, there was actually nothing Spanish about the contagious disease. It was actually rampant among all of Europe's combatant armies and countries, but underreported due to military censorship. But in Spain, which was neutral, the coverage was unchecked. So you similarly have here, so eerily similar to today, you know, you have your dictatorships in China, Taiwan. We don't know if the reporting figures accurately. Similarly, in 1918, we know that no other countries except for Spain were, and that's how it got the moniker the Spanish flu. But this is from a New York Times article. There's also a book by Michael Wallace called Greater Gotham. Great book. It's a two-part series. If anybody's interested or a history buff, especially in New York City, no better book. There's no better book out there than Gotham and Greater Gotham, which covers every single tidbit of New York City history that you could ever imagine. I use it like an encyclopedia. Really great. So get that if you're interested. Okay, so you know, some of the larger publicly traded companies and the national chains here who have the financial wherewithal are probably going to be able to weather this COVID-19 storm. We're going to see how long of a recession we have. I think all the financial experts are pretty much unanimous in their opinion. We are going to have a recession. It's just a matter of how long that recession is going to take. Last recession we had was in 2008. We had a relatively quick bounce back, especially here in New York City. The property values following the 2008 recession came back very strongly, very quickly. Only time will tell what the ramifications and ripple effects on the economy from COVID-19 are, but they are sure to be far worse than what we saw in 2008. Now, we touched a little bit about the CARES Act. We have some influx of substantial capital by the federal government to help out some of these small businesses. We may be getting an additional influx of capital. They're working on that in Capitol Hill, and you know, we'll monitor the situation here and then see what happens going forward. But the tenants that are unable to renegotiate better terms with their landlords are likely going to be seeking court intervention to excuse their obligations. If you have a landlord-tenant situation, a lot of the ones that I'm dealing with, that's what I have at play. So they're going to be seeking abatements on rental obligations as a result of the closures, as a result of the physical damage that has been caused by the viral matter that sticks to surfaces from COVID. Again, there are conflicting reports on this, but people think that it's an extremely virulent virus, and it sticks on metal for up to 3 to 4 days. Your doorknobs, your stairwells. Some people say that it can last in the air if somebody sneezes in an elevator and you get on it 30 minutes later, you can pick up the virus. So these litigations for contractual non-performance are going to be waged in courts as soon as they reopen, whenever that is. And, you know, barring an interjection here from the legislature, they're going to be first determined on the contract plain language and meaning. So if you don't have an explicit contractual force majeure in a provision, similar to what we saw in the cases that developed post-Taylor and Taylor itself, going forward, courts are going to have to be determining whether to extend force majeure to the COVID-19 situation to excuse performance. And I've spoken to a plethora of landlord lawyers. I also represent landlords, but when I'm on the tenant side, and all, I think unanimously, the landlord's lawyers see the writing on the wall. They believe themselves that either the courts or the legislatures are going to be excusing non-performance where there is not a specific explicit contractual force majeure provision. So again, I cannot stress it enough. It is critical. The first thing to do is to look at the contract, and that's true with anything, any legal matter. So you have to look at the contract first and see what it says. That's your guiding point. That's your Bible. All right. So at the same time that these fights are being waged, insureds are also seeking recovery to account for major business income losses under their policies of insurance due to government-mandated closures. Every single restaurant in New York, and if you are representing retail clients, restaurants, clothiers, whatever the case may be, have your clients put their carriers on notice of a potential claim. Even if the carriers are saying no, they're going to decline coverage, make sure that your clients are protected by affirmatively making that claim with the carrier. So unless the legislature passes some legislation providing that the business interruption claims covering the COVID-19 pandemic will be covered, then these battles are going to be played out in the courts. And they're going to be played out over the course of the next several years. And their outcomes are largely going to depend on the plain language and meaning employed by the policy at issue. Here we have a footnote. Thomas Keller sued. That's a case out west. But you're seeing this more and more every day. I think there was one in Florida that was filed not too long ago. You're seeing these restaurateurs suing their carriers. They're what's known as declaratory judgments, where there's a justiciable controversy, the controversy here being whether the policy provides coverage. We're going to look at that a little bit later in the lecture, but the critical query on the insurance side, particularly with respect to business interruption or business loss coverage, is whether or not COVID-19 constitutes physical damage to the building, right? We know what physical damage in its traditional sense means. Somebody takes a hammer and to a brick facade of a building, that we know is the traditional physical damage. Does the viral matter sticking on surfaces, high-touch surfaces, which then requires a building or property manager to clean and disinfect, does that equate or rise to the level of physical damage as we know it? And that's what the courts are going to be grappling over. That's what the legislatures are trying to adopt policies language over, and we will see. There has been no definitive court ruling on it yet, and no legislature has passed a bill on the subject yet. So here we get into the language of the contract. We know the language of the contract prevails. New York law, as well as probably every other jurisdiction, is crystal clear. When parties set down their agreement in a clear, complete document, the writing should, as a rule, be enforced according to its terms. And, these considerations in New York especially are all the more compelling in the context of real property transactions where the commercial certainty is of paramount importance and where the instrument was negotiated between sophisticated, counseled business people negotiating at arm's length. And the most often cited case in New York is Exhibit 6. It's WWW Associates, Inc. versus Giancontieri. I've also cited another one here, Vermont Teddy Bear. That one's also cited quite a bit. If you have a breach of contract case in New York, you are certainly citing to Giancontieri. That case was an action for specific performance of a contract to sell real property. There was an ambiguous reciprocal cancellation, an unambiguous reciprocal cancellation provision, right? So in the contract, there was a clause that said either party could cancel the contract. One of the parties wanted to get out based on extrinsic evidence, but the court said the contract was clear, did not care if there was parole evidence or there were certain conversations outside of the four corners of that contract. It was clear what the contract said. It allowed either party to get out. So when it plainly manifests that intention, it will be upheld, and the court will be guided by what's written in the contract. I actually just won a very important appeal in the case of Corman v. Corbett. That came down last week from the Appellate Division 2nd Department. I successfully created a new carve-out to the statute of frauds. In Corman, the Appellate Division agreed with my arguments. It found that an alleged oral contract for the sale of real property did not violate the statute of frauds. It's a landmark case. I'm happy to send you the citation for it. In that case, my clients, a husband and a wife, the husband is a lawyer, the wife is a medical doctor, moved into a split family home in Brooklyn, befriended the prior owner who then died. But before she died, my clients provided life care services for her, and the parties had agreed that upon her passings, insofar as my clients continued those services, the property would be sold to them for a specific price. They were going to meet with the attorney a few days before the decedent passed away to strike up their contract and put it in writing. Unfortunately, she passed away, and the court, again, agreed with my position, holding that a court sitting in equity can issue specific performance for the sale of real property, even where there's no written contract. So it's a case of first impression, created new law, and it's a good one to cite. So moving right along here, we're staying on the contractual language. There has been a recent case out of the Court of Appeals in New York, which New York is a little bit different than other states. Most other states, the highest court is the Supreme Court. In New York, it's the Court of Appeals. We have 159 MP Corp. Redbridge, Bedford, LLC. It's Exhibit 7 in the materials. More recent case, as I said, this was a plaintiff, a commercial tenant's waiver of the right to commence a declaratory judgment action. So in this case, it's a commercial tenant. The parties who have their both sophisticated businesses, there is a specific waiver that the parties agree to, waiving what is called Yellowstone relief. What is Yellowstone? Yellowstone is the famous case by that name, First National Stores versus Yellowstone Shopping Center. It is the strongest weapon, one of the strongest weapons that a tenant in New York has to stop an eviction in order to protect its valuable leasehold. So all cases in New York are guided by summary proceedings, which had been promulgated by the legislature to deal specifically with real property. Landlord brings an eviction case. It's called the summary proceeding because it's very quick and fast, but it allows, the Yellowstone case allows a tenant to stop that proceeding in its tracks and slow the case down and bring it into court, where you have a full ability to conduct discovery as opposed to civil court, where you generally can't get any discovery. So it is a very, very effective tool for tenants. The Court of Appeals in the Redbridge case said that, yeah, sure, parties agree to anything, especially when they're sophisticated, when they're being represented by counsel. So it allowed that waiver to stand. And this case wasn't reversed by a subsequent case, but a legislative action. The legislature said that Yellowstone relief is void as public policy. So that aspect of the Redbridge case was overturned, but Redbridge is still very, very good law on the fact that sophisticated business entities can contract for anything under the sun, except for Yellowstone, of course, and that the parties will be held to the benefit of their bargain in that regard. So still a very important case, and particularly on contractual interpretation. That's one that you want to cite to. And the same principles that guide contractual interpretation that we just discussed apply also to insurance contracts, which are construed in favor of the insured. And where they are clear and unambiguous, they are afforded their plain and ordinary meaning. And that's the United States Fit and Guarantee Company versus Annunziata. That's a Supreme Court case. And now we're going to get into the act of God. Does COVID-19 qualify as an act of God? This has been performance in the commercial sense. So we begin with the premise that shadowed COVID-19 pandemic. I think certainly there was a complete failure on all levels of government here in the U.S. I don't think anybody realized the full potential. Maybe they should, maybe they shouldn't have, but certainly nobody did. And now it's sweeping the globe, especially here in New York City. And you're going to see in a clause in a contract, you will see things such as pandemic, virus or bacteria. Those things you will see. And certainly if you are a transactional lawyer representing a company or a landlord, you want to, depending on which side you're on, if you're on the tenant side, you want to take those things out. But if you're on the landlord side, you want to inject as many possible episodes to your force majeure provisions. COVID-19, bacteria, virus, microbes. You want to make sure all those things are in your force majeure provisions. And if you're a landlord, you certainly want to also end any force majeure provision with the fact that if any of these events are triggered, they do not suspend the payment of a tenant's rental obligations, right? So, and obviously, if you're on the other side, you want to carve those or prune those things out in order to protect your client, as the case may be. So, we just went through this. I've given you some specific examples here: virus, bacteria. Here's the practice tip: when you then look to see for the or in the alternative, sometimes it also allows for termination. And again, if there is an abatement of rent, and if there are contradictory provisions. So, for example, if you have a force majeure provision that says the parties' respective obligations are suspended in the event of force majeure, but the tenant's obligation to pay rent is not, then see if there are other provisions in that contract which do specifically abate rent. So have a damage policy provision that says abate that the rent is not abated. Okay. And the case is that into an issue of who drafted it, who was the principal drafter, but those are the things that you want to look at. So generally an act of God reference is found in a contract's force majeure provision, and if it's triggered, it allows for suspension of the contract, or as I said, in some instances, outright termination. And New York specifically identifies and defines acts of God. You want to look at your own jurisdiction to see what the definitional language is for act of God, but generally it's, without the aid of any interference of humankind, and which cannot be avoided by human prudence and force. We have the arrow, it's exhibit 8 to your materials, right? We're turning back the clock here. We're going back to 1864. Specifically, the act of God under New York law, right? There was a sinking of a steamboat on Hudson while it was traveling from Albany to Manhattan, and it was of contact with the mat of a fluid which had been sunk previously in a squall 2 days before, and it was not considered to be an act of God. Why? Because there was a boat that was sunk in the water beforehand, right? It could have been avoided with prudence and foresight. So New York law is also well settled in that force majeure provisions are narrowly construed, and they only non-performance where the force majeure clause specifically includes the event that actually prevents a party's performance. And in terms of force majeure in New York, the Kim Corp versus Markets Inc., which is in your materials as Exhibit 9, is the single most important case on force majeure that we have today. It's a 1987 case. Clearly, this case is going to be expanded now under COVID-19, so you want to pay particular attention to this case. In Kim, in early 1980, leased a vacant supermarket in Clifton Park, New York, from the defendant. The lease was for an initial term of 10 years with 2 5-year renewal options. The understanding between the parties was that the plaintiff was going to use the property as a roller skating rink open to the public, and the lease required the plaintiff to procure and maintain in full force and effect a public liability insurance policy or policies in a solvent and responsible company or companies. There was a specific parameter of amounts that was supposed to be covered for a single accident. And after the initial insurance policy lapsed, Kim was unable to obtain a policy within the contractual defined parameters, and therefore sought declaratory relief based upon possibility it couldn't get it on the open market. So, you know, the critical issue there was where the force majeure provision of the policy did not specifically include the inability to procure or maintain insurance and doesn't fall within the catch-all or similar causes beyond the control of such a party will a party's non-performance be excused. So the holding, again, it's a narrow holding. The impossibility excuses a party's performance only when the destruction of the subject matter of the contract makes performance objectively impossible, right? This goes all the way back to Taylor, the first case we looked at from England, where force majeure was created. Moreover, the impossibility must be produced by an unanticipated event that could not have been foreseen or guarded against in the contract. Thus, only if the force majeure clause specifically includes the event that actually prevents the party's performance will that party be excused. So New York is dealing with majeure provisions extremely narrowly, which may not be such a great thing, for example, for tenants or retail clients that are on the other side of these contracts. So here again, we have some additional examples of force majeure events, right? Pandemics, quarantines, and this list, again, is non-exclusive. So where a party's force majeure clause explicitly defines a specific event, such as a pandemic, quarantine, national governmental order, it's going to excuse performance as a consequence of COVID. Right? We know that the WHO has declared COVID a pandemic. Globally, not only a national emergency, but a global one, and a very serious one. All right? All state governors have issued quarantine decrees. As I said earlier, which provide that the rent will not abate, even where there is force. This is a bargain, meaning that, for example, in a commercial restaurant, they will not be entitled to any rent abatement during the period of shutdown unless you can find some other provision like this before. reference to rental abatement, and then make the argument that COVID constitutes a casualty or constitutes a damage. There's going to be cases. The law is developing on this issue, right? Us lawyers are going to be the ones that are going to be forging and developing this new law. So notwithstanding, non-performing parties are going to predictably argue that because the government social distancing rule spaces are rental obligations. So again, you always have to go back to the contract. But traditionally, cover natural disasters like Hurricane Katrina and Superstorm Sandy, as opposed to pandemics, right? So there is a difference between acts of God. Acts of God are specifically defined based on the jurisdiction that you're in. So take a look at the case law and see how acts of God are specifically defined within your respective jurisdictions. So for the contract, triggering the force majeure for COVID, but which merely refer to an act of God, it's going to be very interesting to see how courts expand the act of God definition to cover COVID-19 scenarios, given the colossal economic destruction. It's going to be hard to really imagine courts not extending the definition, in my opinion, of an act of God to COVID and these force majeure claims. And if the courts do ultimately extend the definition to cover COVID, it's going to be universally applied as defense against breaches based upon non-performance, and is also certainly going to widely be used to renegotiate commercial contracts in COVID-19's aftermath. So as I said, I'm doing these now across the country, and I generally get various, depending on the landlord, depending on the property. Some landlords say, no way, we're not giving you any abatement. We'll offer you maybe a deferral. The deferral is like a loan. Abatement is forgiveness. So there is a stark difference between abatement and deferral. Those are two legal terms of art. And certainly if you're representing a tenant or another party under a contract that you're trying to seek non-performance under, that's what you want to be angling for, is abatement. You want forgiveness. You don't want simple deferral. And a lot of these landlords now, in the context of these negotiations, they're asking for whether or not the tenant received PPP monies, how much, claim are mandated by the lease, the guarantee at issue. So, you know, these negotiations, you have to take each one on its own. Separate contracts, you got to look at the contracts first, and then you have to make very well articulated arguments to support either abatement or early lease termination if you're on the tenant side. Okay, so now we're going into the business interruption claims. So particularly with regard to business interruption claims filed by an insured under their policy of an insurance, the coverage is typically only applied when a suspension causes a direct physical loss or actual damage to the subject property, which I think I touched on a bit earlier. Currently, there is no direct authority in New York holding that insurance business coverage is provided in instances where the property in question needed to be remediated using antiviral agents, such as what we have now with COVID. And whether the viral matter attached to surfaces within the property actually constitutes property. So again, this is going to be an area that is going to be carved out by courts going forward, or the legislature. To cover the relevant period of restoration of damaged property, but there are no cases directly on point extending period of restoration to eradication of bacteria or virus. And that case is in note Roundabout Theater Inc. versus Continental Casualty Company. It's Exhibit 10 in your materials. It's a very important case. The business interruption clause of an insurance policy that was issued to the plaintiff theater company was found not to cover losses occasioned by an order of the city of New York. And the accident happened in the area in the absence of any physical damage to the theater premises, right? And it 35 loss in the form of ticket, related sales, as well as additional expenses incurred in the reopening of the production. But the court looked at the language of the business interruption clause in the policy at issue, and it clearly and unambiguously provided coverage only where there is a direct physical loss or damage to the insured's property. So those are the key terms: direct physical loss, or not COVID-19 viral matter which sticks on the surfaces and requires cleaning and sanitization. So in the Roundabout Theater, losses resulting from that off-site property damage, we restricted the access to the theater. This theater did not cover under the policy. So the lower court found that it did. They were reversed. And the $1 million, again, coming back to it, is whether or not the sticking of the COVID-19 viral matter on physical surfaces constitutes a direct physical loss or damage, right? That's what courts now are deciding, or again, the legislature. So you'll have to step in to make that change and bring it into play. All right, so we already see here a tremendous level of coverage claims being filed. I have been telling my clients across the board, if they have business losses, to immediately make a claim with the carrier. You should all be telling your clients the same thing to represent them on these types of cases. And of course, we're monitoring very closely what the legislature in each state is doing. Sure that not only COVID is covered, but similar viruses that happen in the future are covered. This way they don't have to pay out on any of these claims. So you're going to continue language here. So if you look at some of what what's going on with the legislature, I think New Jersey was actually the first assembly to have put a bill together on this, and that's in the materials as well. It's Exhibit 11 in our materials. You can take a look at the language of the proposed bill. The bill was actually retracted shortly after it was submitted in committee. But the express language of that prior bill indicates and was applicable to COVID-19. New York has a very similar bill. Happen. So certainly if one of these legislatures does pass such a bill extending coverage, we are going to have litigation on behalf of the carriers is likely going to be a class action lawsuit for declaratory judgment filed by the carriers against the government on constitutional grounds, because essentially if the legislature does step in and pass these bills, carriers are saying, legislature, you can't rip up my prior policy of insurance that I negotiated at arm's length with the insured, right? That's a violation, and it clearly offends the contracts of the Constitution. Article, and I think, you know, quite frankly, the carriers have a pretty good legal position. But you know, we'll see how that plays out if the legislature actually does take this initial step. And you know, interesting to note that the legislature did not enact legislation giving further clarification on business interruption. Katrina or Superstorm Sandy. But at the same token, the business closures resulting from COVID are not localized. This has resulted in a complete shutdown and closure of our entire economy as we know it. So it's certainly more widespread prior events, right? See how these things play out. Very interesting to see. So let's get into the doctrines of impossibility, frustration of purpose. Even assuming the courts hold that COVID-19 does not equate to an act of God or force majeure or trigger business interruption, which I strongly believe that either the courts or the legislatures will. The litigants can still rely upon these common law doctrines of impossibility or frustration of purpose to get around their contractual obligations. And I've cited some of the main body of case law on the issue, also Corbin on contract, section 76.5. According to the law of impossibility, performance of a contract will be excused if such performance is rendered impossible by intervening governmental activities, but only if those activities are unforeseeable. That's the key term right there, and that's from the case, which, as I said, is the most important case in New York to be expounded upon as we move forward here. So, specifically, a party seeking to rescind a contract has to show, again, even if the intervening act consisted of the actions of a governmental entity or the passage of new legislation, some other additional cases here to look at. So under this rubric, the litigants are going to be arguing the governor's orders restricting shutting down businesses certainly qualifies as an unforeseeable event at the time of execution of the contract, and certainly no one could have foreseen this pandemic, hence rendering performance under the contract impossible. We'll see how, if courts in the different varying jurisdictions take more liberal views under this doctrine and when they're evaluating these claims flowing from the COVID-19 economic years. The frustration of purpose, also closely related doctrine. Similarly, very narrow, generally used as a defensive measure here in New York. And again, unless the frustration is substantial, the party cannot rely upon this doctrine. The main case is the Farley Realty Corporation, which is cited here. And in order to trigger the doctrine, the frustrated purpose has to be so completely the basis of the contract that as both parties understood it. Without it, the transaction would have made little sense. So you can see here the interplay between all these very closely related, but also different. So we'll see here. I mean, you know, these governments are to be at least temporary in nature. So the ultimate purpose upon which these contracts are based, especially if I'm a landlord, at some point there is going to be restoration here. So it does not render the contract or the purpose of the contract impossible or frustrated, right? Because at some point these spaces are going to open again. And this, as usual, will be safe to pursue. So the frustration of purpose doctrine, in my opinion, is going to have a relatively limited level of success. This is certainly the last doctrine I think that your expectations of the other states, similar laws regarding these doctrines and possibility and practicability, frustration of purpose. This is where I'm negotiating. These are the states where I'm more heavily negotiating these. So I have some cases from Florida. You practice in Florida, Nevada, Texas, California, and the cases are very closely aligned in terms of the doctrines that are espoused. So take a look at those cases. Also have, as I mentioned, California, which I think the California courts are going to take a more liberal view on these force majeure cases. Okay, so although the COVID-19 pandemic is still relatively nascent, the destruction that it has caused to us as a society, to human life, our economy, is unprecedented. I've never seen anything like it in my life before. I'm sure many of you have not either. And it's started to open up the floodgates of litigation. We pointed out that Thomas Ellis, there have been a myriad of other lawsuits already started over this very issue. And what we do know is that throughout our history, catastrophic events have led to litigation, which has ultimately helped shape new laws and new legal doctrines, as will COVID-19. So the legislature does not step in to define force majeure or acts of God. For purposes of non-performance, commercial contracts under COVID-19, then the courts are certainly going to be shaping the framework as we have discussed in the context of this lecture. And similarly, the catastrophic event, the legal modifications in the insurance realm, we're seeing that. COVID-19 is not going to be any different. And should the legislature not intervene to clarify whether business interruption is covered, and the court's going to be grappling with this issue as well on the coverage side, and ultimately determining whether COVID-19 tends to cover damage, or it is an actual physical loss. No, in the traditional sense, thereby triggering a policy's business interruption coverage, and along with a host of constitutional challenges that will occur on behalf of the carriers if the legislatures do, in fact, push that legislation. And I've also provided here in the notes and materials an appendix with actual language that I've taken from some of the contracts that I have been working on and negotiating rent relief or early lease termination in various states. Aside some of the language. Substantiate non-performance under force majeure. So you can take a look at that when you're doing these. Some of the pertinent issues in place. I believe that concludes